Hi, my name is Eddie Cortez, and I'm an attorney here in Houston, Texas, with 20 plus years of experience in the field of criminal defense. And today I want to go over a subject with you that pertains to virtually all cases, plea bargains. Now, there are basically three factors that go into every plea bargain. I don't care if it's a misdemeanor, DWI, or a major felony. The district attorney's office is allowed to consider your priors, the facts of the case in front of us, and what it is the victim or law enforcement wants to do when they're deciding what sort of plea they're going to offer you in this case. So, last subject first. If the victim or the victim's family wants you buried under the jail, they're going to come at you hard. If the victim doesn't really want to be involved or doesn't want to testify or recants, they're going to offer you something more reasonable. That doesn't mean they're going to dismiss the case, but they're going to offer you something more reasonable. Law enforcement generally are not going to get involved in plea negotiations unless you gave them a hard time when they were trying to take you in, cussing at them, spitting at them, things like that, or you have some information that they can use on a subsequent investigation on someone else. That's usually in drug cases, and that's what they refer to as turning state's evidence. I generally don't recommend that, but sometimes that's the only card you have to play. Facts of the case are pretty simple. If it's a slam dunk, they have a ton of evidence against you, they caught you red-handed, they don't have to give you a good deal because they know if you go forward to trial, the judge or the jury may give you more time than what they're offering. On the other hand, if it's a weak case or there were constitutional violations in the acquisition of that evidence, there's not a lot of evidence against you, then they're going to make you an offer you can't refuse. Why? Because they want you to plead guilty to something. They don't want you to walk out of there with a not guilty. And finally, they're going to look at your priors. And when we talk about priors, we mean anything and everything you've ever been arrested for above a traffic ticket. I don't care if it was dismissed. I don't care if it happened when you were a juvenile. I don't care if it happened in another state. A prosecutor is legally authorized to look at anything and everything in your background when they're deciding, okay, what are we going to offer this guy? Obviously, somebody with a clean criminal history, it's going to go a lot easier for them. Whereas someone who has a pretty long sleeve, a lot of priors, they're going to say, well, this guy obviously hasn't learned his lesson, so they're going to come at him a lot harder than somebody who's a newbie. So if, for some reason, you cannot come to an agreement with the state, there is no bargain you're willing to sign, there is no plea you're willing to sign for, then and only then does the heavy lifting begin in the case where you start preparing the case for trial. So way before you get your day in court, they're going to try to offer you something to convince you to avoid the cost and time necessary for a full-blown trial. And honestly, the vast majority of cases get resolved that way. But as I said, if there isn't something you're willing to sign for, then the only option at that point is to go to trial. Hopefully this helps you out a little bit. Thank you for listening.